Hi, my name is Jonathan Wilson, and I'm a partner in the law firm of Taylor English Duma here in Atlanta, Georgia, and I'm here to talk to you today about Startups 101. I've been working with startups since I was in college when I founded my first software company in 1986. That was a long time ago, but a lot of the same principles that we had to learn back then are still applicable today, and I have used them with dozens of startups over my 30-year legal career. So, if you're a startup, you need to think about this as a journey. You're getting ready to take a long trip, and you need to get prepared for that journey. So a lot of the things that you do in the early days of getting your company organized are going to serve you well over the months and years ahead. So the first thing you want to think about when you are forming your new company is what kind of company should you be? Are you going to be a corporation, a limited liability company, or a partnership? Each of these three entities is a little bit different, and it helps to have some understanding of what their differences are. Each one of these entities is created by the filing of a document with the Secretary of State in one of the 50 states. Now, people often ask, if I'm living in Alabama or Mississippi, do I need to create my company in Alabama or Mississippi? The answer is no. You can form your entity in just about any one of the 50 states. In most situations, though, it's going to be more economical for you to file your documents in the state where you live. One of the few exceptions to that rule is when your corporation is getting ready to go public. And for that reason, a lot of startups often file their corporate documentation in the state of Delaware. Delaware is a good state to be in if you are a large corporation that is getting ready to go public. Unfortunately, though, for a lot of startups, this is actually involving a lot more work than they want to do, and there are additional fees involved in the state of Delaware. So unless you have the sort of company that is underway, that is already attracting a lot of investors, already making a lot of money, it's probably not worthwhile to go to Delaware in the first instance. So 9 times out of 10, I'm going to encourage you to file your corporate organization in the state where you live. Now, should you be a corporation, a limited liability company, or a limited partnership? Here are the differences. With a corporation, you file a document with the Secretary of State that defines the number of shares. For each class of shares, you have to have some very specific information about what those shares are, common shares, preferred shares, and so on. And you have to have other information about the number of directors, and so on. With a limited liability company, you don't have to file any of that very confidential information with the Secretary of State. You have a very short document that provides the name of the company, provides an address where it's going to do business, that identifies its registered agent, and that's it. You don't even have to say who you are when you file the document. And for a limited partnership, it's pretty much the same as a limited liability company. So between those three, you could go either way. My personal preference is for a limited liability company for some reasons we'll get to in just a minute. Now, the other thing that you need to think about when you form your corporation is who's going to own what and who's going to be involved in that formation. In many startups, there are a handful of individuals who are involved. 2, 3, 4, 5 people who are coming together to create some new product or some new service. In those situations, it's very convenient to form a limited liability company because a limited liability company also has a contract called an operating agreement. For an LLC, the operating agreement is basically a statement of what the deal is among the founders. In the case of a corporation, you don't really have the same concept. You have the articles of incorporation that are filed with the Secretary of State. You then have a document called bylaws, which is sort of like Robert's Rules of Order, how you hold meetings of the board of directors and the shareholders. And then you have other documents that fill in all the gaps about what the deal is supposed to be. You might have a shareholders agreement in which the shareholders agree with each other about who's going to be on the board of directors and who's not. You might have an investor rights agreement that defines how people are going to be able to sell their shares if we ever go public, and other documents like that. But there's this proliferation of documents that takes place when you form a corporation. In the case of an LLC, all of those concepts get bundled up into the operating agreement, and for that reason, it's often a lot more convenient for most startups to begin life as an LLC. The good news is you can always change your mind later. If you are an LLC and you're getting successful and you're attracting lots of investors, you can always convert your LLC into a corporation, and it's a fairly simple process to make that happen. The other thing that founders of startups need to think about is how they're going to raise their money. Are they going to be selling equity or are they going to be selling debt? Put simply, debt is a loan. You borrow money, you pay back the lender, and then you pay back some interest, the earnings that the lender makes on the amount of money that they loan you. In the case of equity, you're actually selling a piece of the pie. An equity investor is going to own some fraction, some percentage of the company forever, whether it goes up or whether it goes down. So fundamentally, as a founder, you need to think about whether you want to sell a piece of the pie, a piece of your company that's going to go on forever, or do you just want to borrow money and then pay it back with interest? Whether one avenue or the other is going to be better for you is going to depend on your business plan and how successful you're going to be. Another key difference between corporations, LLCs, and partnerships is the way that they are taxed. Here things can get a little bit complicated, so I would encourage you always to consult a tax lawyer when you form your company. Corporations come in basically two flavors, what we call Subchapter C and Subchapter S. A Subchapter C corporation is taxed as if it's its own entity. That Subchapter C corporation is going to file a tax return, it's going to pay tax on its earnings, and then if it distributes any profits to its shareholders, those shareholders are going to pay tax on the amount of cash that they received. So, Subchapter C corporations we usually refer to as having two levels of taxation. And for a Subchapter C corporation that is throwing off lots of cash to its shareholders, it's actually less efficient often than having a single level of taxation. Now, for corporations and LLCs, the other alternative is to be a Subchapter S corporation. Here's where it gets a little complicated. You could be a corporation that is taxed as a Subchapter S corporation, and you can also be an LLC that's taxed as a Subchapter S corporation. You need to keep those two differences in mind. Whether the one makes more sense for you than the other or not is going to depend on advice that only your tax advisor or your tax lawyer can give you. So I won't be able to cover all of those details in today's presentation. We talked about an LLC that can be taxed as an S corporation. It's also possible for an LLC to be taxed as a partnership. And this is the method of taxation that makes sense for most small businesses. When an LLC is taxed as a partnership, that means that cash comes into the LLC, and at the end of the year, the LLC sums up its books and records, and it issues to each member of the LLC what's called a K-1. The K-1 is just the name of the IRS form that gives to each member of the LLC some fraction, some percentage, of the LLC's total earnings. That individual member then has to pay tax based on their percentage share as distributed on the K-1. As a result, there's only one level of taxation. The LLC itself doesn't pay any income tax. It just parcels out the income to the members for them to pay tax on their percentage shares. So, for most new startups, it is more efficient to be an LLC taxed as a partnership because of that single level of taxation. Whether one outcome or another makes more sense for you will depend on your particular facts and circumstances, so I would encourage you to talk to a tax lawyer or your tax advisor before making any final decisions. Now, if you form your company as a limited liability company, one of the first things you do is put together an operating agreement. That operating agreement is usually going to be between 30 and 40 pages long, and it's going to define the relationship among the owners of the LLC, which we call members. In particular, it's going to describe how the LLC makes decisions. Will the LLC have a single individual who is designated the manager, or will there be a committee, sometimes called a board, that makes the decisions? Either method works. It's going to be a function of what you and your co-founders agree to, but all of that agreement is going to find its way into the operating agreement of the LLC. Now, there is no one particular way of making this work, but there is probably 80% of an operating agreement that is comprised of tax information, and it won't change very much from document to document. You'll need to talk to a lawyer who has done these sorts of things before to find the form that fits your business best. But as we said, for an LLC, all of that information is going to go into the operating agreement that you sign with your co-founders. If you do form your company as a limited liability company, it's important to realize that you won't be able to take that company public. You can make the LLC as big as you want. It can be successful into the terms of billions of dollars, but it's never going to be able to go public. But that's okay. You don't need to worry about that. If your LLC is successful, it is possible to convert it to a corporation at a later date and then have that corporation go public. It also doesn't matter in which state you've organized. You could be a Georgia corporation converting into Delaware before you go public. You could be an Alabama limited liability company converting into a Delaware corporation before you go public. Either way works, and if you're successful enough as a business, you'll be able to find the way to get to the end result that you want. Almost every startup needs to raise money from investors, and this is one of the most difficult processes that founders of startups find. The fundraising process is difficult not only because it involves accounting concepts and business concepts, but it also involves a lot of legal concepts. In particular, when a startup is raising money by talking to investors and asking them to invest, it is actually engaged in a solicitation of securities. And the solicitation of securities is something that is governed in the US, both at the federal level and at the state level. We're going to talk mostly about federal law here, but be aware that there's also a state level component that you're going to have to comply with as well. On the federal level, solicitations for investments in securities are governed by the Securities Act of 1933. That's a mouthful, but the main idea is that every solicitation for the sale of securities needs to either be registered or exempt from registration. Now, registered securities are the kind that you buy on the stock market, so they're not applicable to you when you're a startup. What that means is that every startup, when they try to raise money from investors, has to engage in an exempt transaction in securities. Now, there are about 5 different types of exemptions, but I'm going to talk about the one that is almost always applicable, and that's called Regulation D. What Regulation D allows the startup to do is sell securities in the company to investors who are accredited. What does it mean to be an accredited investor? Accredited investors, when they are individuals, natural persons, either have income of $200,000 or more for each of the last 2 years, $300,000 if the investor is married and files jointly with his or her spouse, or the individual investor has a net worth of more than $1 million, excluding the investor's personal residence. So $200,000, $300,000 if married, net worth of $1 million, not counting the personal residence. If your investor can check either one of those boxes, then they are accredited, and that means that you can do a Regulation D exempt offering with them. You may have heard about crowdfunding. Crowdfunding is another avenue to go, but it gets a little bit more detailed. We're not going to get into that today. But be aware that there are 2 different types of Regulation D offerings, what we call 506B and 506C. In a 506B offering, the startup is selling its securities to accredited investors with whom it has a prior substantial relationship. That means you know the investors. You didn't meet them online, you didn't make a speech and they approached you after the fact. You have some connection to the investors that exists before you ask them for money. 506C is a different type of offering, and that means that you are able to advertise in public. Now, it may sound like 506C is the way to go. You can advertise, but the difference is on the back end of the transaction. In a 506B offering, the startup is selling its securities to accredited investors with whom it has a pre-existing substantial relationship. And in the documentation, each investor is going to sign and certify that they are in fact accredited, that they have the $200,000 or the net worth. As long as everyone believes that that statement is true, that's good enough. The startup company that is selling the securities is not in trouble with the SEC if it turns out that the investor was lying. In fact, the investor is the one who's going to be responsible if the investor is lying, if they said they were accredited. In contrast, Rule 506C takes a different approach. In Rule 506C, there's a trade-off. The investor, rather the startup, is able to advertise its offering to all the world, but it's only able to accept funds from investors who are actually accredited. And the burden is on the startup to prove that every one of its investors is actually accredited. So in a 506C offering, we either ask the investor to provide a copy of their tax returns, provide a letter from a lawyer or an accountant, or go to a third-party service provider that actually will certify that investors are accredited. Now, either 506B or 506C can work for you. Which one is going to be more convenient will depend on your facts and circumstances, including the process you're planning to follow to obtain your investors. In each case, be aware that this is a very complicated subject. It involves federal securities law, and if you get it wrong, there can be both civil and criminal consequences. So it's a good idea to consult a lawyer who has done this sort of thing before you engage in an offering of securities. So, when you're doing your offering of securities, it's important to keep in mind whether you are or are not permitted to make a public solicitation. When you're doing a Rule 506B offering, you are not permitted to do a public solicitation. That means that all of your communications with potential investors need to be in private. If possible, have your investors sign a non-disclosure agreement, which your lawyer can provide for you. By doing that, you're creating a paper trail that you have not made any public solicitation for investors. If you're making a 506C offering, you can make as many public solicitations as you want. You can put up a website that offers your securities for sale. You can put a billboard by the side of the road. I've even heard advertisements on satellite radio for investments in 506C offerings. All of those things are possible because of the way the Rule 506C works. But be aware that any discussion, any communication of any kind, whether it's oral, in writing, in an email, in a text message, has the potential to become a public solicitation of securities if it identifies your company, makes any reference to the fact that you're trying to raise money or sell securities, and contains any information about the value of your securities or the pricing of your offering. Those elements put together constitute a public solicitation, and you can only make those in the context of a 506C offering. All of the discussions with potential investors in a 506B offering need to be made in some sort of a confidential context. So I mentioned crowdfunding earlier, and crowdfunding can come into several different shapes and sizes. We don't have the time to get into all of those different alternatives today, but I do want to talk about the two most popular types of crowdfunding and how they might apply to you as a startup. We talked earlier about the Rule 506C offering, how it allows you to make public solicitations for investors so long as every one of those investors is accredited and the startup is able to prove that they are accredited either by getting a letter, getting a copy of tax returns, or having a third-party certification service work to certify that the investors are accredited. The other type of crowdfunding is called Regulation CF. Regulation CF is something that was created by the 2012 American Jobs Act, and it's a relatively recent phenomenon. But it's important to know the difference between Regulation CF crowdfunding and Rule 506C offerings that are a part of Regulation D. It's important to understand the difference because both can happen on a website or through an online platform, and either one might be a feasible alternative for you as a startup. For a Rule 506C offering, every single one of the investors has to be accredited, and the startup has to be able to prove that they are accredited. And there are companies out there, like Start Engine, for example, where startups can go and offer their securities for sale to accredited investors under Rule 506C. In contrast, Regulation CF crowdfunding, the kind that was created by the 2012 Jobs Act, can only happen on a licensed crowdfunding website. 506C, you can make solicitations through the website, across the web, by email, or in public. You can get up on the side of the road and make a speech, and it can be a legitimate 506C offering. In contrast, a Regulation CF offering can only take place within the confines of the licensed online platform, such as Start Engine and some of the other alternatives that are out there. Either one can work for you as a startup, but it's important to know the differences. The other key difference is, in the 506C offering, every one of those investors has to be accredited. In a Regulation CF offering, investors do not need to be accredited. There are limits on how much money an investor can invest based upon their particular income and net worth, and those are details that you're going to want to review with a securities lawyer, but you can take in some non-accredited investors in a Regulation CF offering. The other really big difference between 506C and a Regulation CF is that there is no limit on the amount of money that the startup can raise in a 506C offering. You could do a fundraising for $100 million if your business justifies it. In Regulation CF, there is a strict $5 million limit per year, every 12 months, that a company can raise under Regulation CF. So, depending on where your body of investors is likely to come from, and the other facts and circumstances that are unique to your business, Regulation CF or Regulation 506C could be the way to go. Again, these are complex topics, and I would encourage you to consult with an experienced securities lawyer before making any final decisions. So, you've formed your startup, you've decided that you're going to make some kind of a securities offering, You've engaged securities counsel and you've talked about the difference between Regulation D and Regulation CF, Rule 506B and 506C, and you've made your decisions about how you're going to conduct the offering. What you haven't determined yet is what kind of securities you're going to sell. You might remember at the beginning of our talk, we talked about the difference between debt and equity. Let's assume for the sake of argument that you're going to do an equity offering. You still need to decide what type of equity securities you're going to sell, and there are several different kinds. There is the idea of common stock and preferred stock. Common stock, which we can use that phrase to refer to a corporation, we can also use it to refer to interests in an LLC. Common stock is basically the idea of the lowest possible denominator of ownership of the company. After all the creditors have been paid, after everyone else who has been paid that has some sort of priority claim, all the remaining value when we sell the company is going to go to the common stockholders. Common stockholders usually have the right to vote, and they have that base level ownership of the company, whether it's a corporation or an LLC. In contrast, preferred stockholders have a different set of rights. Preferred stockholders have the right to get their investment back, might have the right to get some level of percentage dividend back, and usually their claim has a priority above the common stockholders in the event the company is sold. Most investments into startups take place at the preferred stock level because investors in a startup know that it's a risky business, many startups fail, and they want to know that they're going to get their money back before the common stockholders get paid. How much money they get back, what percentage of the ultimate liquidation price of the company that might be, these are all things that you will need to work out, usually in a financial model that you develop in combination with your CFO or your financial advisor and your legal counsel. Now, there are two other variations on this that you should be aware of as a startup. One is called convertible notes. Convertible notes were very popular in the 1990s and the early 2000s. They haven't become quite as popular today, but it's important to understand them before I tell you about the other alternatives. With a convertible note, the investor makes a loan of a certain amount of money to the startup. The investor has the right to get back the investment plus interest, or the investor can convert that note into equity in the company. The equity could be common stock or it could be preferred stock. All of these different if-then type scenarios get spelled out in the investment agreement between the investor and the startup. The advantage to the investor is that in the event of a liquidation, creditors get paid before equity owners, and the holder of a convertible note is a creditor. The creditor has made a loan to the company. So if you are an investor in a startup and you're not confident that the startup will be successful, you might want to structure your investment as a convertible note so that you would have the advantage of being a creditor if this startup does not succeed and we end up having to fight over the scraps to see who gets paid. As I mentioned, convertible notes were more popular in the 1990s and the early 2000s. Within the last decade or so, however, there is a new structure called a SAFE, a Simple Agreement for Future Equity. The SAFE was invented by an incubator in California called Y Combinator. You can go to their website and you can download copies of the forms for free. They have a very helpful primer and some materials that explain how the SAFE works. But the idea of the SAFE is to make it possible for the investor to invest in the startup in a way that eliminates a lot of the complexity of the convertible note. You might remember when we talked about the convertible note, we said that you would have the right to get your money back plus interest, or it could convert into some kind of a security. Well, just imagine how complicated that would be to write up into an agreement. Lawyers can do it, of course, we do it all the time, but the document ends up being 20, 30, 40 pages long, and it gets a bit complicated. A SAFE is usually 4 or 5 pages long, and the way the SAFE works is like this. The investor puts money in, and at any time that there is a sale of the company, the investor has the right to get the money back. Or the investor could get the amount of money that would be attributable if that investment was converted into equity at a particular ratio, all of which is spelled out in the SAFE. The advantage is that neither the startup nor the investor has to make a decision about how much the startup is actually worth at the time the investment is made. The SAFE just converts automatically when there is a liquidation event, like a sale of the company or another large investment into the company that is priced on a per share basis. So For my particular practice in the last 5 years, I have done most investments into startups through the simple agreement for future equity, or SAFE, and I think that is becoming much more the standard these days. So I would encourage you to investigate SAFEs when you are thinking about raising funds for your startup. So, before you're ready to talk to investors about investing in your startup, there are a bunch of prerequisites that you need to have completed. We said at the very beginning of this talk that preparing your startup is a lot like taking a journey. You need to have a bunch of things collected and ready to go with you because you're going to have to carry them with you for a long time. Well, I want to talk to you about what some of those prerequisites are. And they're things that are important to put into place when you form your startup before you start talking to investors. First of these is that you need to make sure that your company is duly and properly formed. If it's a corporation, you've filed your articles of incorporation, you've adopted bylaws, you have formed a board of directors. That board of directors has held meetings, and those meetings have been documented in written minutes. Your corporate counsel can advise you on how to put all those forms together. If you are an LLC, you will have formed articles of incorporation, articles of organization, and you will have a written operating agreement with your founders. If you don't have those things done, then you aren't really properly formed as an LLC. Another key piece of the puzzle that you need to have is a document with every one of your participating founders, everyone who became a founder of the company at the time it was formed, that assigns to the company all of the intellectual property that is owned or created by that founder in the course of their working with the company. This is something that's often overlooked by founders, but if you don't have it, then your company really isn't complete. After all, why would an investor want to put money into your company if they don't know that all the intellectual property created by the founders hasn't been contributed into the company? Your investors want to know that the company has all of the intellectual property assets required to run the business that is going to make it successful, and those individual assignments of intellectual property rights with every one of the founders are an important piece of that. The other thing that your startup is going to need to have is an employment agreement with every individual who's working. Just because you have 4 or 5 individuals who come together and form an LLC and do this startup business doesn't mean that they're actually properly employed. Having a legal employment relationship between the company and every one of the individuals who is doing work is an important part of the due organization of the company, and it's something that investors are going to want to look at. In addition, investors are going to want to know that all of the founders and all of the employees who are actively engaged in the business have appropriate restrictive covenants in place between themselves and the company. This means some kind of an agreement for every one of the important employees that says that that employee will not leave and form a competing business. They won't leave and work with a competing business and try to solicit the customers or the other employees of the company. And they won't leave and try to take any of the confidential information or trade secrets of the company away if they leave the business. Those sorts of restrictive covenants are important so that investors have the confidence to know that the startup that they're investing in has all of the intellectual property and all of the assets and all of the human resources it needs in order to be successful. This is only a short version of the list of all the prerequisites that you want to have for your startup before it talks to investors. So be sure to consult with an attorney who has done startup work before to make sure that you have all of these prerequisites in place before you begin the process of starting to talk to investors. Now, in your conversations with some investors who are a little bit more sophisticated, there can be other issues that come up. And some of these will get a little bit complicated. You're going to need to lean on your lawyer a lot when it comes to these issues. The first of these is called dilution. Now, let's imagine that you are one of 4 founders of a company. So together, you and the other 3 comprise 100% of the business. And you do an initial investment transaction with an investor who puts in a certain amount of money, and for the sake of argument, let's say that they are buying common stock in your corporation, and the amount of money that they put in, you agree, represents 20% of the company. Well, the 4 founders, you and the 4 founders, were originally 25% each. You are now 20% each, and your new investor is another 20%. All 5 of you together are 20% each, or 100%. That investment transaction resulted in dilution. You had 25%, now you had 20%. Hopefully, if you've done it right, your business has grown enough and has benefited by the cash that was put in by that new investor to make the dilution worth it. Well, let's imagine that you're successful, you grow the business with the funds that you obtained from the first investor, and now you need more funds. Your first investor doesn't want to invest anymore, so you're going to talk to a second investor of putting money in. Will all 5 of you now be diluted at a similar rate, or will some be diluted faster than others? That is the dilution question that can sometimes be negotiated with a sophisticated investor in an investment agreement. I can't go over all of the different alternatives that are possible today, but that is something to be aware of and something that you'll want to talk to your lawyer about when the time comes. The other idea, related to the idea of dilution, are called preemptive rights. Let's go back to our hypothetical where we had 4 founders, 25% each, and a new investor comes along who puts money in, and that person obtains 20% of the company. So then you have 5 investors, each with 20%. One of the things that that new investor might negotiate for is a preemptive right. The idea that the corporation cannot sell more securities to a new investor unless that first investor has the right to buy those securities at the price that is being offered. And that way he would be preempting the rights of the new investor. That is a concept that some sophisticated investors may negotiate for if they think that the company is going to be successful and they want to have the right to take on all the subsequent investments to basically preempt all future investors at whatever price the company is able to negotiate with a third party. Preemptive rights, something that can be negotiated. In addition, sophisticated investors will often negotiate for information rights. This could include the right to get copies of contracts, the right to get financial statements on some periodic basis, even the right to participate in preparing the company's tax returns in advance. Sophisticated investors will often ask for these information rights, sometimes even the right to put a person on the board of directors as a condition to making their investment. When it comes to more sophisticated investors, there really are no limits to the sorts of information rights that they might request. So again, it's good to have a lawyer that has done this sort of thing before you start having those negotiations. Finally, in companies that are further along, that have had maybe several rounds of investment, that have substantial revenues and are probably on their way to either being acquired by a larger company or perhaps even going public, investors may sometimes negotiate for registration rights. Now, the organization called the National Venture Capital Association, or NVCA, has a standard form of investor rights agreement that includes substantial discussion of registration rights. This can get very complicated, but it's something to be aware of that more sophisticated investors will ask for. Again, make sure that you have an attorney working for you who has worked with these sorts of issues before so that you can get the information you need before making any final decisions. So, these are some of the issues that involve startups that are getting formed for the first time, that are talking to investors about getting financing, that are engaging with their founders, with their employment agreements, with their assignments of intellectual property rights, and all these other prerequisites that every startup needs to have before they can talk with investors. At almost every turn, it's important that the startup have a lawyer to work with who has done this sort of thing before. These are complex issues that take years of practice to get right, and you ought to spend some time getting to know your lawyer before you embark on the journey of being a startup. What sort of things should you look for? Well, I think it's important to have a lawyer that you can get along with. Sometimes these transactions involve a lot of time in conference rooms and on the phone and on Zoom calls, so make sure that you've got a lawyer that you're comfortable talking with. A lawyer who has done these sorts of transactions before, who can give you examples of other clients that they have worked with, who are willing to talk to you and share hopefully positive experiences about working with this lawyer. And feel free to ask questions. Lawyers are not inexpensive. It can be quite expensive to hire a lawyer, but at the same time, you don't necessarily want to hire the cheapest lawyer. What you ought to do is ask what's involved in this transaction. What are the steps that I should expect? How long should it take? And what would be a reasonable budget for the legal fees involved in the transaction? Lawyers who do this sort of work often are familiar with the processes, are familiar with the time frames involved, and should be able to give you a fairly precise estimate of the amount of the legal fees. Sometimes these transactions can be done on a fixed fee basis, where the lawyer will take on the work from Part A to Part B for a certain amount, and other times they're done on an hourly basis. The hourly rate isn't necessarily the most important thing if the lawyer is efficient enough to get the work done in a way that's going to fit within your budget. So feel free to ask for advice from the lawyer, to ask for a quotation, ask for an estimate of what the fees will be, and make sure that you hire a lawyer that makes you feel comfortable. After all, the journey of a startup can be a long one, and you want to make sure that you have all of your advisors who are equally teamed with you for the entire journey in a way that's going to make it as comfortable and as successful as you can make it be. So that is Startups 101. My name is Jonathan Wilson. I'm a partner at the law firm of Taylor English Duma, and if you would like to talk to you about your particular situation, I would be happy to talk with you. Just reach out to me on the web and we will schedule a call to talk, and I look forward to hearing your story. Thank you.